Have a good day. This matter will be submitted. And this takes us to the last item on the 10 o'clock docket. Docket number 363092, Tiffany Fields versus Sayers Inc.
More acquiescence.
This is a property day.
I was hoping I had the quintessential case, Your Honor. Apparently I've been one up. Yeah. May it please the court. Thank you. This is a case involving a disputed area of land that is roughly 123 feet by 37 feet.
Will you put your name on the record, counsel?
I'm sorry, Fred Macraz, M-A-C-K-R-A-Z, I'm here on behalf of the plaintiff and the appellant. This piece of property is depicted on Exhibit 1. My client's property is 24 Daniel. It is to the east of the defendant property, which is a gas station, 4809 Division. There was, as quintessential acquiescence case should have, a fence. And the fence was in place since 1992 when my then 7-year-old client moved into the house. She has since inherited the property, and that's why she is the plaintiff. What's important to note, I believe, is there is no dispute about the use. There is no dispute that for more than 15 years, this fence was treated as the boundary line between the property owners. The Sayers defendants purchased this property long after the acquiescence period had expired. So
There's some suggestion that there was an oral contract about allowing your client to use the property as long as they kept it cleaned up and cut the grass and so on.
the suggestion comes from what I think is being classified as a public record or a police report. There's two issues with that. One is it is not a police report. It's hard to know what it is. It looks like a printout of something, a discussion that was had between an officer and my client, Tiffany Fields. It is levels of hearsay. It is unauthenticated. But more important than that, in my mind, Your Honor, is what they are suggesting has been resoundingly rebuffed by the courts to say in an acquiescence case, unlike in an adverse possession case, this idea of consent is not an element, right? And in fact, Judge Yates and Judge Shapiro fairly recently were on a panel, Kuzma versus Schnetter. It's an unpublished decision, but you considered that exact case, that exact issue. And acquiescence doesn't require hostility, and whether there is or is not permission is irrelevant. And that was citing Walters versus Snyder, which is a published case, of course. So I think the trial court erred here in that it looked and put weight on a planning commission hearing in 2013, long after the 15 years had expired. What the trial court said, hey, you didn't object, you didn't raise heck that they were talking about this rezoning that encroached on what was your property. That a couple of problems with that are, again, we have minutes. We don't have a transcript of that discussion. We don't know exactly what was said. It would be speculative to say that you didn't object. However, whether you object or not is, again, irrelevant. It's not an element for acquiescence. It's not recognized as an element. And again, Judge Shapiro, you were on a panel, Morocco versus Vandenberg, cited in my brief, was unpublished, considered the exact same issue. In that case,
the docket numbers for those two cases?
I do.
Or are they in your brief?
One of them is, yes. Morocco is in my brief. The case with each of you on was Kuzma versus Schnetter. That's 2022 WL 177-25807, 2022 case. In the Morocco case, the USDA classified property and the classification was on the actual boundary line, not on the historically used boundary line. The exact same argument was made. Hey, you didn't object. And what the court said was, you're not required to object. The 15 years has passed. That is your property as a matter of law. You don't have to object every time someone says something that may be inconsistent with your rights. And again, that was citing Walters versus Snyder. So there are published decisions that support that.
Mr. Macraz, what do you want us to do here? Because in the previous case, it came to us with the benefit of a 3-day bench trial. Everyone testified. We knew exactly what happened. There's no question about it. Here, the trial court granted summary disposition against you under C10, Do you want to win on summary disposition, or do you want to go back and just have a bench trial or a jury trial?
I think it's appropriate to remand with instruction of the court to enter an order quieting title for the reason that all of the elements are satisfied and there is no dispute. If there was a factual issue, if we were arguing about what was the use here, I was using it in 1998, then we would have to have a bench trial. We don't have that here. It is absolutely undisputed, and I've listed all the different ways that that disputed area was used by my clients. It is far in excess of what cases have found is sufficient to establish a boundary line based on offense. So my request is to remand, have a quiet title order entered, and there is another item of trespass, which is a cause of action. One of the ways we used this disputed area was putting up a shed in that area. And it had a lawnmower, it had some items in it. After the defendants in 2018, I believe, in 2021, removed the fence, moved the fence. Well, they took their shed and they
They
destroyed
didn't
or
take it, they knocked it down.
they knocked it down. It's gone. We don't really know. Yeah, they knocked it down and we don't know where the contents are. So I believe that is the remaining issue that should go back to the trial court. We should have a hearing on that issue, whether it amounts to trespass or conversion, Judge Yates' favorite cause of action, conversion, we may,
Right.
we may amend, but that issue needs to be resolved and whether there are damages. So with that, if there are any questions? Thank you.
Next time you can add me to your list of acquiescence cases.
I will look for the public's opinion, yes.
Thank you. Good morning.
Honors. My name is Ed Vanderplug. I'm here on behalf of the defendant appellee, Sahers LLC. Sahers.
Thank you.
Mr. Vanderplug, before you get started, let me ask you the same question I asked Mr. Macris. I presume since you moved under C-10, you take the position that there are no genuine issues of material fact. We just need to resolve this case one way or another right now, correct? I mean, we have de novo review, obviously, of Judge Rossi's
Right.
ruling.
Exactly.
So your view, as well as Mr. Macra's view, is that we just need to declare a winner and be done with it. I mean, I know there's that trespass claim out there.
There was a discussion on the record about that with Judge Rossi when we argued the motion for summary disposition, and it was left as an open issue as to what would happen. Would we come back and have to have a trial and have him listen to the fact witnesses? But he brought the issue up.
Right.
And at that time, it was, well, there's no jury demand here. It's inequity. I'll have to figure this thing out and I'll get back with you. That's how it was.
Okay, thank you.
A plaintiff in this case has the burden of proving acquiescence. And to prove acquiescence, he or the plaintiffs in this case, the Fields, have to determine when Sahers or its predecessors in interest were deceased or dispossessed of the property. So our position is never in any 15-year consecutive period going back to 1992 when plaintiff's Tiffany Fields' father bought the property, Mr. Diehouse, that there's never been a 15-year period since then where there was continuous use of that property or there was an overt or tacit agreement for them to use the property. And the reason I say that is because when you look back at the evidence that was presented to the trial court to Judge Rossi, we have several instances that have occurred that would support that proposition. Number one, we have plaintiff Tiffany Fields, who twice admitted to a Kentwood police officer that there was an agreement between her father and my client's predecessors in interest that Mr. Diehouse and his family could use the property as long as they mowed the grass, going back to Judge Yates's comment earlier. In effect, our position is there was either an oral lease or a licensing agreement that emerged because of that agreement. In other words, the predecessors in interest never overtly or tacitly said, now go ahead and use the property, we don't care. It was, use the property, but in exchange, there's consideration there to mow the property and take care of it. That's admitted by Ms. Fields twice. And she says in those admissions that goes back 30 years to when my father first acquired the property.
But at least as far as acquiescence goes, there was a fence, right?
There was a fence, yes.
So that is, I'm not saying it's definitive, but that's one of the hallmarks of acquiescence, right? Fence gets put in the wrong place, line of bushes or line of trees gets put in the wrong place, and everybody lives with it for years and years and years.
Except in this case, it's different.
Right. I
Because
understand, but it's similar in the sense that there was some sort of physical indication of where a property line might be. I'm not suggesting it's definitive or it's outcome determinative, but there was a fence.
there
yes.
was a fence. Yep. Secondly, in addition to this license or oral agreement that had been in place, Mr. Diehouse himself was aware that Ms. Sahers LLC had gone to the city of Kentwood. She was about to purchase the property. She runs through all of the requirements through the Planning Commission and the City Commission. He receives notice, and we've included that as an attachment to our brief, that there's going to be this hearing to rezone the property. And it was going to be rezoned from residential to commercial. He goes to the hearing. His son speaks up at the hearing. And the only concern that was expressed was, well, are they going to move the fence closer to our driveway? So there's no quid pro quo here or anything else that anything other than, well, I guess we get to continue to use the property as long as we continue to mow it or do what we orally agreed to do back in the early 1990s. There was no objection by Mr. Diehouse at that time. He was also notified of the City Commission meeting that was held a month or two later to actually approve the Planning Commission's recommendation to rezone the parcel.
They actually rezoned in a manner inconsistent with where the fence was.
That's one way to look at it. And I don't mean to be difficult, Your Honor, but it was going to be rezoned from residential to commercial. Nobody's objecting to it. Everybody is saying, yeah, that looks like all the boxes have been checked and we're going to move forward with it.
So may I ask, we've talked a little bit about this, but the statements, I appreciate that opposing counsel sees them as problematic for several reasons. But if we accept them as true, does it really matter? I mean, because the 15-year period already lapsed a decade or more ago. So what impact, I'm trying to wrap my head around whether those statements even really have any impact in this case.
They do, because they further solidify the agreement that was made back in the early 1990s that this is a transaction. This is either a lease or a license, or you're going to mow the grass here in exchange for use of the property. And those statements by Tiffany Fields back in 2021 and 2020 further indicate, oh yeah, there was an agreement that goes back there. And I know that we've honored that agreement going back 30 years now. So it's further evidence that what Mr. Diehouse, who is now deceased, was on the mark with what was being conveyed.
I might, maybe I'm placing too much emphasis and I want you to tell me if I am, but it would seem to me that would be more compelling if there actually were a writing signed by the interested parties that this is a lease or this is a license. I mean, there's nothing. What we have is the fence, and we know that the plaintiff mowed their side of the fence and there wasn't any issue for, multiple decades. So is that a deficiency in your claim because there is nothing in writing? I mean, how can we,
If there was something in writing, we probably wouldn't be standing here today.
right?
But what we also then have
Mhm.
is the spontaneous action of Mr. Diehouse in late 2013 or 2014 when he goes to my client's member in her convenience store and tells her, hey, I'm George Diehouse. I have the parcel next to yours. I just want to make sure that you know that this is your property over here. So he admits it. It belongs to you. I'm being the honest guy and telling you, hey, you're new here. And I just want to be honest with you. And that's also consistent both with the statements, Judge Rick, that you just referred to, as well as what Mr. Diehouse indicated that, yeah, there was this agreement here that goes back to the early 1990s.
I'm going to chew on that.
Pardon me?
I'm going to chew on
Okay.
that.
I appreciate it.
Yeah.
So we've got consideration exchange. We've got these, at least these three instances that are indicative, at least from our perspective, that this is not simple acquiescence. There's no tacit agreement. There's no overt agreement. This property was purchased by Sahers LLC, and nothing came up about this until my client decided, let's make this clear. Let's move the fence over to where the boundary is and clean up this matter. There were some comments made by opposing counsel about the shed and the toys. There's no record evidence of that, what happened and why. I know why things were not returned, but that's not on the record here, and I don't necessarily think it's relevant to your decision unless you want to hear about it, but I don't think we need to go there. So I'm back to, when did descussion occur? And descussion has not occurred in this case. It never occurred because we've had all these circumstances where Saher's predecessors in interest were never disavowed of the property at any point in time because of these agreements that had gone on over the 30 plus years since.
Let's assume for purposes of argument that they had been, that the property had, they had acquiesced in the property being possession of the other party. Do the events post that nevertheless indicate that acquiescence is no longer applicable, or that there's an estoppel problem? I mean, I'm puzzled by if the acquiescence occurred a long time ago and there's these post events, what's the relationship?
Our position is acquiescence never occurred.
I know
and
that.
Descussion never occurred.
But I'm asking, if you're wrong about that, do these post-deceasing events change the outcome?
I think they changed the outcome from the standpoint that they go back and they support our original position.
But can there be acquiescence and then acquiescence by the other side to a different outcome?
Or some kind of waiver or estoppel, that's
Right. So anything like that, I think the question is, if there's the 15-year period of acquiescence, can anything undo that?
That's a great question, and I wish there was some case law that settled that one way or the other.
Yeah, well, Judge Shapiro gets credit for that great question, not me.
I didn't have a great answer either.
I will go back to the Houston case, which was cited in both briefs. And that case is distinguished from this one as well, in that involved some disputes over legal ownership versus equitable ownership in a land contract situation, and is further distinguished from the fact that the defendant in that case never presented any evidence to show that there was a contrary point of view. Our view is we've got much evidence that was presented to the trial court here that suggests otherwise, and why acquiescence didn't occur, even if it's interpreted under Houston.
I have another question that I'm confused about. I find this acquiescence area of the law kind of confusing. So if there's this 15-year period, and then there's a case brought in order to memorialize the acquiescence, let's say. Has the acquiescence occurred before the case was filed or only on that judgment? I mean, in other words, where do we date it from?
And that was my whole point of my argument.
Well, I guess I wasn't paying attention.
I'm sorry. I don't mean to sound short, but I go back to the descussion situation. They were never deceased of the my client was never deceased of the property, or the predecessors were never deceased. So the 15 years never ran. I have two other things very briefly. This case started with 3 counts in the trial court. We've spent a lot of time on acquiescence, and that was the part of the motion of summary disposition that plaintiff brought on cross motions. In our presentation to the trial court and to this court, there was also adverse possession and trespassing, and that is not dealt with in specificity in the trial court's written opinion. And so I tried to cover it in our brief, and very briefly, the adverse possession argument we don't believe holds water. We argued to the trial court that the hostility issue was never met, and the exclusivity element was not met. And then we had a C8 motion on trespass because our view is the property belonged to Sahers and you can't trespass on your own property. So I just wanted to put that on the record. Thank you for your time.
Thank you. Brief rebuttal.
Of course, questions. Your
Sorry,
Honor,
this is a fascinating case.
it is, they're all fascinating. They are interesting. And I believe the case law supports the fact that after 15 years, that becomes the boundary line. It's the end of the day.
You don't need a declaration from a court to so determine it unless there's a contest.
Exactly. I need to quiet title, so it's now part of title, and the lines get redrawn. However, that becomes the boundary line as a matter of law. And I think the question about can you undo acquiescence? Sure. And there's case law, and there's 3 ways. And we could have acquiescence for the statutory period again. So if we stop using it for 15 years, it reacquiesces. We can undo it that way. The other 2 mentioned in the course, the case Payne versus Elliott, acquiescence following a dispute and agreement. We could agree, you're going to get this back. The third is acquiescence arising from an intention to deed to a marked boundary, so we can deed it back to you. So there are ways you can undo it. But once it is done for 15 years, that is your property, and you have all the rights of a property owner, subject to adverse possession, acquiescence. I think it really is interesting. The argument is, hey, you didn't agree expressly or implicitly. The case law is very clear. Tacit agreement is if you treat a fence as a boundary line for 15 years, it becomes that. That's implicit. I'm hearing counsel argue there was an express agreement. I'm hearing counsel say, mow the lawn, and we're going to treat this fence as a boundary. And we're going to do that for 15 years. I don't think that hurts me. I don't think that hurts me at all. I think the court is correct to say if we're going to argue something about a writing, we should see the writing, or a lease. We're going to implicate statute of frauds issue if we're talking about a lease that goes for 20 years. Right.
May I stop you on the Payne v. Elliott? And I hadn't contemplated this before, but if I'm understanding Mr. Vanderplug's argument, though, that acquiescence was undone when in 2014, George came into the new owner and said, hey, just to let you know, we don't own this.
Yeah.
I mean, why isn't that viable?
2013, Your Honor.
2013, pardon.
Yep, it was not him coming into the owner. We have a planning commission minutes that are not a transcript. We don't know what was said, but
But the minutes are the official record of.
they're the official record, but they don't say, it is speculation to
Right,
say,
right.
he came in and said, this is yours. The record is what the record is. And if Your Honors will note, I believe Judge Rossi is struggling with this issue. I know we're all struggling with this issue. I don't think we can impute to Mr. Diehouse to say, I have acquiescence based on 15 years. If he believes that that is titled there, that does not change it. I think what I brought up to Judge Rossi was, if I came in and said, you own my property today, that doesn't make it so. He is not aware of what his legal rights are under the acquiescence theory. So, Your Honor, I think
So that could start a period of acquiescence back the other way, but it didn't go for the statutory period of 15 years because
Right.
it showed up in 2013 and here we are in 2023, only 10 years down the road.
Well, it's not even 13. I believe it was 13. She purchased the property. It was 21 that the fence got torn down and rebuilt.
No, but whenever he walked in and said,
13, correct. If you want to start,
right.
if
So-
you want to start the
so-
clock.
And the way you would view that, the acquiescence period could have started back the other way, but we haven't reached the statutory period. Before the statutory period was reached, he filed a quiet title action.
Of
So there
course.
you-
And
Or she did.
we filed a
Successor,
quiet
Nick.
title. Yeah, we filed quiet title because the fence on its historic boundary line for 21 years was torn down and put right
Right,
up against.
correct,
our-
from 92 to 2013.
That's
Can
correct.
can I just, I want to make sure that I'm abundantly clear on it.
Yes.
The 2013, I understood, that's when the planning commission meeting took place. I thought the subsequent conversation between George and and Cower was 2014.
Aware of that discussion. You're right. I think there are two things going on here. One is this, the police show up because there's some issue and she says, hey,
That
We
was
have
in
an agreement.
2020,
2020.
right?
Yes.
Okay.
And it may be actually in an affidavit that there was some discussion in 2014 about that. That is part of the record. I believe, Your Honor, you're correct.
Okay, okay.
But I think what the trial court relied on and the reasoning was in 2013, you didn't object. That was really the sole basis of this trial court's opinion. You didn't object when they started redrawing lines. There's no requirement and the case law rejects that. And the last thing I wanted to point out, the presentation suggests, hey, we bought this property and we were amazed. It was a surprise to us. Any commercial property, everybody, you get a survey. You have avenues. You get a survey and you say, oh my gosh, there's a fence on this property. I'm going to do something. I'm going to either get title insurance and be assured against it, or I'm going to negotiate. It's not like this is, oh my golly, I got a pig in a poke. It was an established fence. Survey would have clearly established where that was in relation to boundary line and title insurance would cover it. So are there any other questions?
Thank you. I have none.
Okay,
All right.
thank you.
Great. Thank you both very much. Appreciate your argument. Well briefed. 10-minute break.
Yeah.
We're going to take a 10-minute break. We'll be with you for the next hour.